because if I sit all day in front of that computer, I'm just going to turn into a bowl of jello.
Have you ever been to Monticello in Virginia?
No, I have not.
Well, at Monticello, that's Thomas Jefferson's house. And one of the things they claimed that he invented was a stand-up desk. Did you know?
Oh,
Ah,
well, I should have stopped by Monticello. I think we spent more time at the beach, and then we went through Harper's Ferry. Did you ever head up there to Harper's Ferry and see John Brown's old insurrection launching pad?
I was in Harper's Ferry about 10 days ago.
Wow.
And I've walked the streets many times, actually. Many times. It's a little fort down by the river.
Mr.
Yep.
Hearing Examiner, you're not the host.
Okay, thank you very much, Mr. Kippenbrock. I appreciate everything you do. We're waiting for Mr. Elliott. Ms. Kippenbrock, I think he sent you a request for the URL. Could you take a look at that and send him the URL? I sent it to him, but he might be having trouble logging on. And we're also waiting for Ms. Martinez. I'm not going to start without either of those persons here.
I need to tell you this. It took me a couple of minutes to log in because I got confused with all the links I received.
Thank
So
you.
maybe they are having the same problem.
Okay, thank you very much. There he is. Hi, Mr. Elliott. Welcome back.
Hello.
Now we're just waiting for Ms. Martinez. Okay. Oh, nice. Welcome, Ms. Martinez. Let's just check your audio as well as your video. We can see you.
Good morning.
Good
How are
morning.
you?
I'm great. Thank you for asking. I think we're all great. I think you're the last person to check in, and I appreciate that. We are streaming live on YouTube, so anyone that has internet access can find us and can observe what we're doing, and we appreciate that. State government in New Mexico certainly strives to be transparent. That being said, well, I'm going to announce during the record, once we go on the record, that we had an informal, very short pre-hearing conference immediately prior to this more formal beginning of a hearing. So that's where we are. Are we all ready to go on the record? Yes, we are. Ms. Gonsalves, may we go on the record?
Yes, please.
Thank you. We are on the record now. It is approximately, according to the cell phone, it is 10 a.m. on 10/18, October 18th, 2022. This is a proceeding of the New Mexico Public Regulation Commission. This is the case of the matter, in the matter of request for approval of general rate adjustment pursuant to 17.9540. That's of the NMEC, the Administrative Procedures, filed by Jemez Mountains Electric Cooperative, Inc., the petitioner. This is case number 21-00318-UT. This case was filed some time ago. There's been substantial pleadings filed in this case. There's been substantial direct testimony filed in this case. There's been motions filed in this case. This case was scheduled for today pursuant to a procedural order. That procedural order was generated subsequent to an informal meeting and agreed by the parties. As to the date, this date is the beginning date. We scheduled it to continue until as necessary for subsequent dates. It was agreed between the parties that today would be a date to resolve any outstanding motions, also to receive public comment, which I'll address. And please remind me if I forget about that. I appreciate that. There was, prior to going on the record today, a very brief, I didn't count the minutes, but it was either 10 or 12 minutes or so, pre-hearing conference. And the pre-hearing conference was because of, frankly, very late developments in this very long case at, they call it the 11th hour or 11th hour, 59th minute, which was yesterday afternoon, when I was informed that the parties had reached a stipulation, which is, you know, the word you hear is settlement. It's not really a settlement, but it's a stipulation. It's an agreement to the issues herein. The unique thing about a stipulation in this type of case is that it still has to be approved by the commission. It's not enforceable until it's approved by the commission. That's pursuant to state regulations. The commission has to accept my recommendation as to whether it will be approved or not. My recommendation has to be based upon evidence. So there has to be evidence in support of the stipulation. The issue in a rate case, which this one is the reasonableness of the proposed rates. That is the issue pursuant to the statute, which is New Mexico Statute 62-8-7. I'm looking at paragraph 8, wherein the commission is authorized to conduct a hearing concerning the reasonableness of any proposed rates filed. That's exactly what they did. These cases can proceed with co-ops without even a hearing. However, in this case, a protest was filed. The commission found that the protest was valid. There's certain criteria for that. Once they got over that hump, they decided that there should be a hearing. They assigned me as the hearing examiner to conduct the hearing, and we're having that hearing. The hearing is about the reasonableness of the proposed rates pursuant to the statute. I also issued a procedural order reinforcing why we're here, and the issue to be resolved in this case is the reasonableness of those rates. Anyhow, late yesterday afternoon, I was informed that a stipulation would be filed for my consideration and which may resolve the case without the necessity of a full hearing on the merits. That's the status of the case. That's the thing that was discussed in the pre-hearing, very short pre-hearing conference before we went on the record. I'm going to now ask the persons present to identify themselves with their name and their address and state who they represent. I'm going to begin with the counsel for the applicant, Mr. Yar, please.
Thank you, Your Honor. Joseph Yar, on behalf of Jemez Mountains Electric Cooperative, Inc. I'm at 645 Don Gaspar Avenue, Santa Fe, New Mexico, Your Honor.
Thank you. In no particular order, let's go with Mr. Elliott, please.
Good morning, Gideon Elliott for the Attorney General's office. I am at the office of the Attorney General, 408 Galisteo Street.
Thank you.
Santa Fe.
Seems obvious, but who's your client?
The Attorney General and the people of New Mexico.
Thank you, sir. Mr. Bagatko.
There we go. John Bagatko, on behalf of the New Mexico Public Regulation Commission Utility Division, and we're physically located down here off of 142 West Palace Avenue in Santa Fe, New Mexico. And I am accompanied today by our two subject matter witnesses in this case, Ms. Alicia Leva-Tessero and Dr. Bryce Zadalis.
Thank you. And Mr. Bagatko, who is your client?
My client is the New Mexico Public Regulation Commission Utility Division.
Thank you, sir. Ms. Martinez, again, last but not least, please.
I'm Loida Martinez. I am an intervener. We were one of the protesters that initiated this hearing. And I'm located in Private Drive 1433, House 48, Chimayo.
Ms. Martinez, I understand that you are a pro se litigant, which means you represent yourself and nobody else other than yourself. But I'd like to hear that from you. Is that correct?
I'm a pro se litigant. Yes, sir, and I only represent myself.
Thank you, ma'am. That's kind. Okay, let's see. Okay, just so I don't forget, let's talk about public comment. Usually public comment is done before a hearing on the merits. We're beginning the hearing. I expect we're going to hear some motions, but just get it out of the way because it's easier. Let's do the comment. I received I received 3 items of public comment, but one was filed late. So I'd like to address those 3 public comments. I filed the 2 that I received with the records department of the commission. So they are now public record and anybody can get on the e-docket system of the PRC and can see the 2 public comments. But I'll just name them, and I'm going to ask Ms. Gonsalves to include them as comment in the official record. One, they're both dated October 14th. The first one that came to me was at 9:55. Well, it was sent at 9:55 a.m. That's might not be when I opened it. It was sent at 9:55 a.m. on the last day for submitting comment, which was October 14th. And it's a letter, and it's from a gentleman named Harry Gantz, G-A-N-T-Z. I filed it, and I'm asking that it be included in the record by the court reporter. Next, there was a public comment received the same day, October 14th, the last day in which to send public comment. And that was sent on 4:50 p.m., which is 10 minutes before the close of business. And that was sent by Miss Teresina Y. Berg. And I would ask that Ms. Gonsalves include that one in the record. Now, there was a third one, which was not timely filed. And there are limits on this kind of thing, and they've been set by the procedural order. And the limit was October 14th. And the regulations for computing time things indicate that the close of business, the end of the business day, is the end of the business day. And on a date like October 14th, stuff like this has to be in by 5 p.m. So I'm not going to address any comment that was filed after the close of business. It wasn't timely filed, but I just thought I would mention it in case anybody ever raised it later. It was received, but it was not timely. The last date for notifying of comment in person at this Zoom meeting was Friday, and no one contacted me and let me know that there would be public comment, that they wanted to publicly comment. They certainly could have, but they didn't. And they also could have notified the commission. I checked the e-dockets and no one had notified the commission. Public commenters could have also contacted Anna, the legal assistant for the hearings department. And I checked with Anna and no one had contacted her to do public comments. So no one is making any public comment except for those 2 timely public comments, which are now part of the official record of this hearing. And they are part of the record as filed with the PRC. I think everyone here knows that public comment is not evidence. Lawyers understand that it's not subject to cross-examination. There's a whole lot of other reasons, but it's actually clearly set forth in the regulations controlling the procedure for these hearings that public comment is not evidence, and any decisions in this case must be based upon evidence, as I stated earlier. Wow, I've talked a whole lot at this point, but that disposes of the public comment. Now I'm going to, is there any comment from any of you participants here before I move on to the next topic? None. Okay, great. I mentioned this in a pre-hearing conference, which was done informally, that I see that there's a few motions that need to be disposed of preliminary. I call them preliminary motions. And I would rather do that now. I expect we're going to get to a motion to continue this proceeding. Continuing is, some people call it postponement, but I don't call it postponement because it already started. It's a continuing it to another date. But I expect we're going to get to a motion to continue, but there's some things we can resolve before we get to the motion to continue. One is a motion filed by Jemez to have this case as an in-person hearing. Actually, it's to modify the procedural order that this hearing be in person rather than be conducted by Zoom, and it is at this very moment. And, it's a pending motion. It's a perfectly legitimate motion, and it has not yet been ruled upon. I think I can rule upon it from the bench, even without a writing. It's a relatively simple motion. But I do believe in every motion that parties have a right to be heard. And I would like to hear from Mr. Yar as to why that should be granted, if he still feels it should be granted, and any objection to it. I mean, if there's no objection, it's hard for me to rule otherwise if there's no objection. Anyhow, I'm going to leave it right there and hear from Mr. Yar and his motion to modify the amended procedural order, to amend the procedural order to allow this hearing to be done in person. Mr. Yar.
Thank you, Your Honor. Jemez, at this point, given the position of the case at this point and the development since the filing of that motion, would like to formally withdraw that motion and just withdraw it, Your Honor.
Well, I appreciate that. And, I'm really a stickler. When things are withdrawn at the very last moment, other people might have been expecting to argue that, or maybe join you, actually. So I think I should go around and see if there's any objection to your motion, your moving to withdraw the motion. No particular order again. Ms. Martinez, any objection to the motion to withdraw?
No objection on the motion to withdraw, but I did object to the in-person hearing.
Okay, thank you very much. Mr. Begayko, any objection to the motion to withdraw?
I don't object to people wanting to withdraw their motions usually, so I won't now. And the only other thing I would add is, as a practical matter, Mr. Hearing Examiner, I take it you've been advised that our building will be closed from December 5th to 9th and from the 12th to the 16th because of something about getting new furniture. And I just wanted to alert you to that if it factors into your calculus in any way regarding the conduct of further proceedings. But other than that, I thank counsel for withdrawing the motion, and I look forward to moving forward with this case. Thank you.
Thank you, Mr. Begayko. Actually, that had left my mind. I'd appreciate it if perhaps you could bring that up when we discuss scheduling, and I expect to do that in an informal conference with you, which doesn't really have to be done on the record. So appreciate that.
Yes,
Mr. Elliott, any objection to the motion today to withdraw the motion to amend the procedural order?
No, sir. Thank you.
Okay, I think I've contacted everybody. So there being no objection, that's also easy to rule upon. And the motion is granted. The motion you've just made today, Mr. Yar, to withdraw your motion is granted. There's nothing else to do on it. So we're going to continue the way the procedural order was written. We're going to do this but via Zoom. Next motion I have is motion that was filed September 23rd, 2022. It is, well, I'll just read what it's captioned. Member-owners of Jemez Mountains, with an S, Electric Cooperative Notice of Withdrawal of Request for Intervention in Support of the Rate Increase Request by Jemez Mountains Electrical Cooperative, Inc., out of time. And it's filed, respectfully submitted, by Teresina Berg, Ricardo Barrera, Beatrice Barrera, Sarah Chavez, and Marcia M. Roybal. And what they request, you guys can see this. I presume that you all received a copy of it because there's a perfectly valid CO, certificate of service on it. They state those individuals provide, they carry, they're not lawyers, I presume, but they characterize this pleading as a notice of withdrawal of motions for intervention filed on August 17th and again on September 23rd. So they can call it a notice. For me, it's a motion, even if they call it a notice. So I consider this a motion to withdraw two of their motions to intervene. And obviously, you know, I'm going to do the same thing housekeeping wise. I'm going to make sure this is clean. And I'm going to ask if there's any objections to this motion. Mr. Yar, since you are represent the applicant, I'm going to continue to ask you for comment first. So, Mr. Yar, are you familiar with this pleading that was filed on September 23rd? And do you have comment?
I am familiar with it, Your Honor, and I don't object to it, Your Honor.
Okay, Mr. Bogacchio, do you object or have any comment?
Mr. Hearing Examiner, no comment, no objection to the withdrawal.
Ms. Martinez, any objection or comment?
I filed an objection, but I have no objection with withdrawal.
That was just a little tiny bit confusing. What was the nature of your objection to their withdrawal?
Well, not with the withdrawal, with them coming in. There's two motions.
Okay, that's actually the opposite. So you're fine with them withdrawing their motion to intervene.
That's correct, sir.
Got it. I just wanted to make sure we're all clear about that. Okay, that's fine. Mr. Elliott, do you have any objection to me granting this motion?
No, I do not. Thank you, Mr. Hearing Examiner.
Thank you. So I think that's as clean as we could possibly have done that. There's no objection. And like I said, it's very easy for me to rule when there's no objection. So they characterize it as a notice. I characterize it as a motion. The motion to withdraw the two motions to intervene filed on August 17th and September 23rd, 2022 by Teresina Berg, Ricardo Barrera, Beatrice Barrera, Sarah Chavez, and Marcia M. Royabout is now granted. So they are definitely not interveners. Just if there was ever any doubt or any concern about that, they are not at this point interveners. I want to mention for the record one thing. I received an email yesterday, 7:06 p.m. And yes, I was in the office at 7:06 p.m. yesterday. And the email, I'm stating this for the record, and like I said, transparency is the very nature of state government. It looks like it's from someone named Sarah Chavez, and I can only, I'm going to presume that it's the same Sarah Chavez that signed this motion to withdraw. At this point, she's no longer even possibly a party, and I could probably talk to her now. But I didn't respond to the email, which was sent to me late last night. I didn't respond to it last night, and I haven't responded to it yet. And if Miss Sarah Chavez is tuned in on YouTube, I want to apologize to not responding, but I hope you understand now why I didn't respond to your email. I didn't even really open it. I just kind of recognized the name, and I didn't think I should because I don't. So anyhow, there you go. That statement has been placed on the record, and you guys understand that. Anyhow, moving along, that's two down. So we also have a very substantial, in my opinion, motion in limine, which we're probably not going to get to. Then I think it's time, if you guys agree, I anticipate that at least one of you, if not some of you or a few of you, are going to file a motion to continue this proceeding on the merits of the case in order to change the nature of the proceedings, to turn it into a stipulation case where stipulation would be filed, evidence in support of would be filed, a hearing to accept the evidence and to do a recommendation, and for the commission to consider the recommendation on the stipulation. That's what I anticipate. If I'm wrong, I ask you guys to correct me. We are on the record. Mr. Yar, is that a correct understanding? And would you like to make that motion?
Your Honor, I would, and thank you for that. And I appreciate your patience, Your Honor. Yes, Your Honor, JMEC at this point, Jemez Mountains Electric Co-op, Inc. would like to make a motion to adjourn or suspend the procedural order or modify the procedural order for the court to consider a proposed uncontested stipulation that the parties have just recently engaged upon. We're happy to talk about it here on the record, or as Your Honor has indicated earlier, at an informal hearing. But, to be brief about it, Your Honor, yes, we would like to make that motion at this point.
Okay, there's a motion. We only really need one. Is that a joint motion? Has anybody joined Mr. Yar with this motion? It's okay if you haven't, but I just want to make sure I'm clear. Mr. Gatko, Mr. Elliott, Ms. Martinez, did you guys agree to jointly make that or no? No?
I'm sorry, go ahead, Gideon.
No, please.
I was going to say, yeah, we have an agreement in principle, so I don't see any reason why staff would not join JMEC in its proposed motion.
Mr. Elliott, does the AG's office join in the motion to continue?
We do. Thank you.
Okay, Ms. Martinez, do you join in that motion?
Yes.
Okay.
Yes, sir.
So you guys have probably figured out how I work. If there's nothing in dispute, it's pretty easy for me to decide. The motion will be granted. You might have noticed that I characterize it somewhat differently. Mediators call that framing, but I call it characterizing in this instance. It was characterized by Mr. Yar as a motion to suspend or modify the procedure order. I really see it purely as a motion to continue this proceeding, because this proceeding has already started and it's going to continue indefinitely to not be reset unless it's reset. Now, as for the procedure order, I'll just do a new procedure order, which supersedes previous procedural orders to the extent that it's inconsistent with previous procedural orders. Now, the contents of the procedural order, I want to make sure this is clear for everyone here and the public, which may be tuned in on YouTube, and I know they're there, and I like to, bring them into this, if not in a two-way, at least a one-way situation. We have a court reporter, Ms. Gonsalves, who's graciously recording everything we say, and some mumbles perhaps, and every once in a while even a motion like a finger wave. And we have a student court reporter, perhaps less experienced, Miss Michelle Ayob, who's sitting in, and court reporting is expensive. We don't need to incur additional expense, and we don't need to do on the record things that don't need to be on the record. Things like comparing schedules of counsel and closing of state buildings and when certain documents have to be filed are the things that get included in a procedural order. And those are precisely the things, those are non-merit things. They are purely procedural, and purely procedural things can be discussed off the record. And that's exactly how I intend to proceed. I intend to invite all of you guys, well, at least Mr. Yar, Mr. Brigatko, Mr. Elliott, and Ms. Martinez to a Zoom hearing, which we'll have after we shut this hearing down, after we adjourn this hearing, adjourn this Zoom meeting, not adjourn this hearing. There is a distinction. And then we're going to have that meeting off the record. And that the pure purpose of that meeting is to compare schedules, talk about dates. There's going to be a date for filing of the STIP, which I want yesterday, to be honest with you. A date for testimony in support of the STIP, the reasonableness of it, which I want almost yesterday. Any response thereto, and I hope there'll be none because this is an uncontested STIP, but we'll talk about that. And then a date for the hearing in support of the STIP. No, to accept evidence in support of the STIP. And that's what we're going to agree on, those dates. And anything else you guys think are relevant that's not a merits type decision, purely procedural. Are there any questions on how we're going to proceed at this point, Mr. Yar?
No, Your Honor. The only thing, as I'm looking at the docket, I don't know if this is just, nitpicking, and I apologize. I noticed that the Attorney General filed a motion for leave to intervene back in August. I know he's filed testimony, and by statute, he's allowed to enter into these cases. I didn't know if Your Honor wanted to grant that motion at this point.
Has there been any objection to his motion intervening?
None from JMEC, Your Honor.
I actually believe that he gets in automatically, there being no motion in opposition, no response in opposition, and no ruling from me denying it. So that's one of those kind of exceptions to the rules where I don't have to clean up shop. If it makes anybody more comfortable, I'm willing to state that on the record. Mr. Elliott, do you disagree with me? Do you think that I need to actively grant your motion for you to be in on the case?
I don't. We do file those motions because hearing examiners don't always express themselves as clearly as you have today.
Thank you, sir. I like the motions. I like it because it gives persons like Ms. Martinez, especially pro se litigants, an opportunity to, Mr. Yar, we can't hear you if you want us to hear you.
No, I'm sorry, Your Honor.
Okay. For the record, Mr. Yar's mouth was moving, but I couldn't hear his audio. Like Ms. Martinez, who might not be familiar with the fact that a motion not ruled upon for intervention is granted automatically. But that's the case here. And so, Mr. Elliott, I consider the New Mexico Attorney General an intervener in the case at this point and for thereafter. Okay, thank you, Mr. Yar. That's a good point. I welcome those good points. Any more?
Nothing further, Your Honor, from Jemez.
Mr. Bogotko?
Just the matter of the motion in limine, were we holding that in reserve, or were we going to have a disposition on that here today?
Thank you. Good question. I consider it a preliminary motion to be considered immediately before the testimony portion of the hearing. And we are not going to reach the testimony portion of the hearing because the motion to continue, did I state expressly granting that motion to continue? Did I, Mr. Yar?
I forget, Your Honor. I thought,
Okay, well,
let's just make sure for the record it's important.
Lest there be any confusion, the motion to continue has been granted. There, that said, it's on the record. It's on the record. Actually, and because the parties are all present and we're streaming, I don't believe it even has to be in an actual order that it's granted. I may restate it as the beginning part of the next procedural order, but it is what it is. I've just granted it on the record. The motion to continue is granted. And because the hearing has been continued, and I believe that that particular motion in limine should be addressed immediately before the testimony, we're not going to reach it if we don't get to that testimony hearing. I'm altered double cautious, and I don't wear actual suspenders, but there's a chance that the stipulation won't result in an order from the commission. There's steps that we need to go through, and we could be back where we are now, actually. And at that point, if we are back where we are now, the next step, unless there's subsequent motions filed or some other activity, would be hearing of the motion in limine. And it's relatively complex. It deals with a lot of various language, gets right down to lines on pages. And if you guys don't know what a motion in limine is, and like again, I'm saying for the public, it means in line. I think it means in Latin to cross out lines, but lawyers understood it as prohibiting the introduction of evidence at a hearing on the merits. So one of the parties has requested that certain evidence be prohibited from admission as evidence. Now, when evidence is moved for admission, I have to rule upon it, and I decide whether it's relevant, whether it's probative, and sometimes there's compound evidence, and some of it's relevant and some of it isn't relevant. And that's where the motion in limine comes in, where someone's not objection to the entire piece of evidence, but believes that lines of evidence should be stricken. So if you guys didn't understand that, that's the way I understand the motion to eliminate. And we may, that motion may take time. That motion may take hours. I just glanced at it and I looked at what it concerned, and it may take hours. It's going to be court reporter hours. It's going to be lawyer hours. It's going to be hearing examiner hours and commission hours. There's a lot of overhead, multiple lawyer hours burned simultaneously. I don't see that it's prudent to spend that to hear the motion and eliminate at this point, because the stipulation may be approved. Are there any questions about that?
None from JMEC, Your Honor. Thank you for that clarification.
Thank you, staff.
No questions. Thank you, Mr. Hearing Examiner.
Ms. Martinez,
None at all, Your Honor.
Ms. Elliott, Mr. Elliott.
No questions. Thank you very much.
Okay, I have one other thing I want to mention. We have two persons here today, Ms. Libia Tessero, who's anticipated as a witness for staff, and you guys graciously allowed her to watch the proceedings this morning, and Dr. Zadalis, who's an economist. I've never met him in person, but I know he works for the commission. I just want to thank you guys for sitting in and watching the proceedings. And we have Ms. Ayoub, who works with Ms. Gonsalves, who is in training, I understand. And we're always glad to have people in training and makes them better when they do this job, when they are the only the only court reporter. If there are no other questions, I'm going to, like I said, I'm going to adjourn the Zoom meeting. I granted the motion. I'm going to continue the hearing to a date yet to be set, may never be reset for the merits, but it may be. And I am going to log off. I'm going to go onto Zoom, set up a new Zoom meeting. I'm going to send notice to Mr. Yar, Mr. Bagacchio, Mr. Elliott, and Ms. Martinez, and we're going to have an informal, off-the-record discussion of dates to be included in a procedural order regarding the stipulation and the necessary procedures for the stipulation. Any questions about that?
None, Your Honor. Thank you.
Thank you. See you all soon. Thank you, Ms. Gonsalves.
Thank you, everyone.
Thank you.
Thank you. Thank you.
Thank you, Mr. Lennon.
Thank you, Ms. Ayoub. Thank you for being here. And thank you, Ms. Gonsalves. Sincerely, I appreciate it.